Okay, as everybody gets into the room, some introductions here. I'm Rob Witters, the farm director at WOWO Radio, and it's wonderful to have you, and it's wonderful to see that so many people are concerned about possibly losing the family farm. We're going to try and avoid that today. So I'm really glad to get a friend of mine and my personal attorney, Dan Gordan, to come and talk to us about that and to bring members of his staff to help with the conversation.
Rob called me a few weeks ago, wanted to know if we would speak at the farm show. I said, yeah, we would do that. And he said, okay, now that you've agreed to speak at the farm show, let me tell you what the topic is. And I said, okay. He said, I've already come up with this great idea. We're going to call it 5 Ways to Lose the Farm. He said, you think you can come up with 5 ways? By that point, I already knew what the 5 ways were, because that's what we deal with every day. The first one, death taxes. Most of us in this room, at least the ones that I know, don't have a problem looking at the federal estate tax today. And that's because the exemption is $12,920,000. And a married couple can fairly easily get 2 of those. There are 3 problems, though, that we need to watch out for. The first one, and probably the most important, is that although that exemption is going to get adjusted for inflation for the next 3 years, January 1, 2026, that exemption drops to half that much. So instead of looking at $12,920,000, we're going to be looking at exemption probably somewhere between $6 and $7 million. And that is a problem for a whole lot of my clients, even when you multiply that by 2. And that leads to the second problem, and that is that when we're looking at those exemptions, way too many of my clients forget to adjust their balance sheets to reflect the fact of what current land prices are. Just about every place that we practice in the northern half of Indiana has seen land prices increase by probably 50% or more in the last 3 years. So, when you're thinking about your estate plan and you're thinking about that exemption, first think about what it's going to be in 3 years, between $6 and $7 million, and then second, think about what your land might be worth. Yesterday, I looked at 6 or 8 appraisals that I had just gotten in over the weekend, and each of those appraisals was of pure farm ground. It wasn't next to a city, wasn't in a particular environment or whatever, but all of those appraisals showed the farm ground being worth $18,000 to $20,000 an acre. And those appraisals were for land within 20 miles of here.
And Dan, you and I had a conversation recently where you were asking some of your customers, what do you think your land is worth? And all of them were way under where they were. Yeah. And I'm talking to Schrader Auctions about helping them promote an auction that's coming up. And they're going in, and they feel like they're low 15 to 18. So the numbers you're talking about pretty much across the board.
Yeah, and so when you're looking at your balance sheet and thinking about talking to us or whoever your attorney might be about your plan, keep those numbers in mind. And clients all the time tell me, well, we don't have to worry about those numbers. My ground isn't worth quite that much. I think that land prices are going to level off, maybe tail off a little bit in the next couple of years, so we don't have to worry about it. They say, yeah, but there are land sales in the area for 14, so I think that's what we're going to be looking at. Here's the thing. If you're gone anytime in the near future, it's not what I think the ground might be worth if it had to pay for itself. It's not what the next door neighbor or your farmer would pay for it. That $18,000 to $20,000 that I looked at yesterday, that's the number that the IRS is going to look at. They're going to find an appraiser that is on the high side, not the appraiser that's on the low side. And they're going to
surprise.
Yeah, right. That's the number they're going to look at when they're figuring out what the tax bill is. So, number one, remember that the exemption is going to drop in half. Number two, use a realistic number. Look at that land within 5 miles or 10 miles that's sold for a bunch of money. And then the third thing to think about is that I mentioned earlier, and this is you'll see this in the farm magazines all the time, that a married couple can get 2 of those exemptions, but you don't get the second exemption unless when the first spouse dies, there's a federal estate tax return filed. If that return is not filed, even though there may not be any tax due when the first spouse dies, but if that return isn't filed, you don't get the second exemption. So if you know someone in your family or friend and the first spouse dies, make sure that they realize that return has to be filed. And it's not a return that looks like your income tax return. I have one laying on my desk back at the office that I have to look at sometime in the next week. It's that thick. So it's painful to put them together. It's painful to look at them, but there is no tax due with that return because the exemption and things going to the spouse covered it. So that's number one. The next part of my talk is what can we do to avoid that problem? There are 3 things that you can do to avoid the problem, and they all involve getting the land out of your name. But they're all covered by the idea of, okay, what we're really doing is we're using our exemption now while we have it rather than waiting until later. So it's a use it or lose it thing. You've got a $12,920,000 exemption today. It's going to drop in half in 3 years, unless you believe that Congress will get something done to keep it the same or raise it in that time period. And the ways to use it, you got to give something away. You got to get it out of your name. It can't be in your name by the time you're gone. 3 ways to do that. Just give it away. You can give it away and use up your exemption. And that could be with an outright gift. Okay, you sign the deed over to the kids. Okay, and I'll talk in a minute about why you got to be careful when you do that. The second way you can do it is you can set up an LLC, put the land into the LLC. Some of you have probably already done that, and then start giving the LLC away a little bit at a time or more. Problems with an outright gift is that once it's gone, you don't control the income in case you wanted to get the income. You don't control anything really on paper. And with an LLC, in order for that to work, you also have to have given up control of the LLC. People say, well, I can still be the manager of the LLC. Well, the IRS is going to look for that. If you're still the manager of that LLC when you're gone, they may say, yeah, you didn't really give it away. So you got to be careful about that. A third way of doing it is a fairly recent development. It's called a spousal lifetime access trust. It's more complicated than most of us in this room want to deal with. I've done a few of them. Because it is more complicated, I'm not going to go into much detail. But the thing about the spousal lifetime access trust, I wanted you to know that it was a possibility so that when you pick up, Successful Farming or Farm Journal or Agri-News or Farm World and you see an article and they mention that as a way to plan, you'll know that they're not fudging, that it really is something that you can do. What you do with a spousal lifetime access trust is that each spouse sets up a trust. It's an irrevocable trust, can't be changed. And generally speaking, those spousal lifetime access trusts provide income to the other spouse. So your married couple had all of the income before the trusts were set up. After the trust is set up, each of them sets up a trust, puts land into it, and then the other spouse gets the income. After it's all done, the spouses still get all of the income. So they didn't really lose the income even though they've set up the irrevocable trust. Problem is the IRS doesn't like them, and they look at it and say, well, unless you're really careful when you set these up, we're going to say that they were reciprocal trusts. And, I can't just set up a trust for Tony and give him all the income of that trust, and Tony sets up a trust for me and gives me all the income of his trust, because the IRS looks at it and said, wait a minute, you guys didn't really do anything. It's the same thing after as it was before. So if anybody suggests to you that you need a spousal lifetime access trust, remember that those 2 trusts that a husband and wife put together probably should not have the same trustees. They probably shouldn't have the same income provisions for each. One might be an option to get the income, the other might be required. I've done some where one spouse did theirs in December, the next spouse did it in January, and I've even seen some articles that said you ought to try to set them up in different states. So anyway, not something that most of us would do, but we can. Okay, number 2 on my list, things to avoid. When you're setting up your plan for the kids, don't assume that they're going to get along just fine, and that they're all going to want to keep the land. And the ones who get land are going to let their brother or sister who farms still farm it. Don't make those kinds of assumptions unless you're willing to watch the farm disappear. Because even in the best of families, the spouses have influence. Times change, income levels change, people retire sooner rather than later. Some people like cash, some people like land. Some people like land because they farm it, some people like land because they want to hunt on it, or whatever. So they have differences of opinion. And it's a whole lot better for your family farm if you have figured out what those differences are ahead of time and tried to deal with them. And one of the reasons that you want to deal with them is that Indiana law since 2012 has favored the child who wants cash. So if I'll use me as an example. I have 5 kids. 2 live in Hollywood, 1 lives in Denver, 1 works for a big law firm in Indianapolis, and 1 lives here in Fort Wayne. But when my wife and I are gone, those 5 kids would look at the situation, and I've got a feeling that one of them might want some cash. Probably not the 2 in Hollywood. It's kind of interesting, but they kind of like land in Indiana because they don't have any place to shoot when they're in California.
Oh, sure they do. Go out to any street corner.
Yeah. Well, they'd have to take their guns with them first, but normally they leave their guns at home. Well, at least I think they have. So anyway, you look at it and say, well, what are these kids going to want, and how do we deal with that? 3 ways of dealing with that. One is you look at it and say, okay, we could give 1 farm to each of the kids. Unfortunately for me, I don't have 5 farms, but you can set it up so that the land can be divided. I can help people figure out how to do that. But the idea would be, okay, if I have transferred farmland either during lifetime or at death to 5 different kids, there are less places for friction to enter into the equation. Each of them wound up with the farm ground around their house, for example. That's something that can be done pretty easily. And so then you look at it and say, well, what else? How does that help the one who wants to farm? And what does that do for for the one who wants cash? They're going to have to sell their share of the farm ground, and what happens to the one who wants to farm? So when you do those types of things, whether you're doing them during lifetime with a gift, or whether it's an LLC, or whether it's a spousal lifetime access trust, you look at it and say, okay, that one who wants to farm needs to have an option to buy if one of the others wants to sell. And all of that can be built into the paperwork now, whether it's built into a deed or whether it's built into a trust for after you're gone. So you can build that option to buy in and help take care of the problem. The other thing that you can do is you can enter into long-term leases with the ones who farm, or you can put an option to rent into those documents that I've just mentioned. So you can deal with the situation where somebody wants to farm without actually taking anything away from the others other than the right to turn it into immediate cash.
And Dan, I think, one of the things that you and I have discussed on so many different occasions is that you guys have seen so much that you've got a lot of options to offer people for a multitude of situations. But really, the bottom line is that oftentimes people are avoiding what they think is going to be a pretty nasty conversation, so they put it off and put it off and put it off. And the point of it is that it's going to end up in court. A judge is going to be dealing with it if you don't deal with it now. And at least if you do deal with it now, and you guys have helped in so many of those family situations, that at least mom and dad have some control, some say over what's going on. I mean, so the bottom line here is it's time to have the tough conversation.
Yeah, the bottom line is start.
Yeah.
You know, that's what happens. Way too often I sit down with people and they say, I've been thinking about doing this for the last 10 years or maybe the last 5 years. Just quite haven't gotten around to it because I couldn't make up my mind what I wanted to do. Well, the sad part about that is they don't know all the options. You know, I've given you, 3 options, but there's sub-options and there are other ways of doing it. They're just, sometimes we have a problem remembering all the different ways that we've done things in the past. We just have to look at it. But the idea is, okay, sit down with whoever your advisor is, whether it's us, whether it's your banker, your CPA. Sit down with somebody who knows all those options and start thinking about the options that you have available instead of trying to figure it out on your own. Now, you can get some help. I mean, I got my Farm Journal this week, and there was an article in there. And I was reminded of an option that I've used in the past, but I hadn't thought about lately, and that's life insurance. So you've got that situation where the child who wanted cash instead gets a farm, and it's subject to an option to sell, and it's subject or an option to buy, and it's subject to an option to lease. But if you had a life insurance policy that gave that child who's getting farm ground that they can't sell, if you had a life insurance policy that put a check for $100,000 in their bank account, okay, maybe
helpful.
Yeah, it helps. Yeah, it makes a little. Now, unless they use the money to hire a lawyer to argue about things.
Again, back to that conversation.
Yeah.
Well, now that you have stolen one of Michelle's lines about, they don't know the options until we sit down and talk with them, and you just brought up life insurance, why didn't you introduce Michelle and let her move on? And Michelle has been with the firm for how long?
Almost 10 years.
And she's got a very big, mean husband, about 6'9". And
he's a gentle giant. It's all right.
Okay.
The next topic we're going to talk about today is, in losing the family farm, is assuming that you will never go to the nursing home, and therefore failing to plan for how you're going to pay for long-term care if you ever need it. So here are the excuses that I hear on an almost daily basis as to why someone does not need to plan on how they're going to pay for long-term care. The most common is probably, my daughter's a nurse and she's going to move in and take care of me for as long as I live. I did it for my mom, she's going to do it for me, we're going to be fine. Well, there's 2 problems with that. First of all, there are some medical needs that even if you have a family member that is trained in the medical field that just can't be taken care of at home. For example, I had a client, many of you have probably dealt with somebody with Alzheimer's in the family, and one of the major symptoms of that can actually be a personality change. And this client became so combative that he could not be kept at home. In fact, he became so combative he could not even be kept in the nursing home, that he had to be sent out to a psychiatric facility. So there are things, whether that's mental capacity or physical capacity, that just can't be dealt with in the home by a family member. Also, your daughter's own life circumstances might change between now and when you need that care. She might predecease you. She might not be around anymore, or her own circumstances could change. Maybe she has a child that has a disability and she needs to be taking care of her own child full-time and therefore can't take care of you also. The second one, I cannot even believe I wrote this down and put it on a slide. People tell me all the time they're going to take their own life before they go into a nursing home. Again, almost on a weekly basis. And similar circumstances, you may not be able to physically do that. Or you may think you can mentally do that now, but you can't later on. And I literally have a client that's sitting in the nursing home that said they were going to do this, made a plan, and failed. So, and your spouse probably won't be able to do it for you either. The last one I hear is, okay, well, I might not have a family member that'll do it, but I'll just pay for someone who does have the medical training to come in and care for me 24 hours. Well, that's fine. That's fantastic, and I hope that for you. But that care is going to cost just as much as a nursing home does. So we need to plan on how we're going to pay for whatever type of care it is that you need, whether it's in the nursing home or at home. I have a lot of people come in and say, okay, I want to protect my farm from the nursing home, and my neighbor did an irrevocable trust. I want one of those. Well, that might be the best option for you, but we're kind of jumping the gun. There are three ways, there's more than three, but three main ways that people pay for long-term care. And people often forget the very first question, kind of the threshold issue is, can you pay for it on your own or not? And so do you have the cash flow to pay for it? In other words, do you have the income to pay for a nursing home without ever having to dip into your other assets, into your operation or into your farm real estate, the stuff you're really worried about losing? Currently, the average cost of a nursing home for a year in Indiana is about $80,000 a year. There's definitely examples that are higher and lower, but that's about average. So the first thing you need to do is consider all of your income. And when I'm talking to people who come in and are in their early 60s, this is actually a very hard question for them to answer, right? They're in their early 60s, they're not yet getting Social Security, so they don't exactly know what that check's gonna look like. They're not taking required minimum distributions from their retirement accounts yet, so they don't really know what that's gonna look like. And they're still farming, so they're not renting out, they're not leasing out their farm real estate yet. They're farming it themselves. And so this actually takes quite a bit of work to really try to estimate what is your income going to be like when you're 85 or 90. All right, but you really need to sit down, talk to your financial advisor, have them help you figure that out, okay? So if you have enough, if you got over $80,000 a year and you're single, then you don't need to go to step 2 or 3. What if you're a little bit shy? Let's say you calculate that your annual income, net income after taxes, is about $75,000 a year. Well, you still might not need to do any additional planning, right? It depends on how many liquid assets that you have. If your annual income is $75,000 and your other assets consist of your home and 40 acres and maybe $20,000 in the bank, well, you probably still need to do some planning, right? Because it's only going to take about 4 years to use up that $20,000 that's in the bank to supplement the 75, and now you're dipping into your farm ground, okay? But if you've got $300,000, $400,000 in investments, and you're only needing to use $5,000 of that a year to pay for long-term care, you're gonna have to be in the nursing home a really long time to make a significant dent in those investments. So if you can almost cash flow it, you might be okay, all right? So let's say you decide there's no way that I can cash flow this. I'm not even close. The second way is to have long-term care insurance. All right. If you have it already, that is fantastic. I would encourage you to have that policy reviewed either by an insurance agent or an attorney to make sure that your benefits are actually going to be adequate to cover the current cost of long-term care. Right? Some insurance policies are going to have inflation riders on them, meaning if you bought it 20 years ago, if it's got an inflation rider on it, the benefit today is hopefully still enough to pay for that care. If it doesn't have an inflation rider on it and you're only going to get $50 a day, that's not going to be enough to pay for the cost of care today. All right, and then you're kind of back to the slide before. Okay, it's $50 a day from insurance plus my income gonna get me up to that 80. All right, if you don't have long-term care yet, I would encourage you to get a quote. The younger and healthier you are when you get a quote, the better. So that's something that you don't want to put that off until you need it, okay? I will warn you that it can be difficult to qualify if you have any type of health issues and that the premiums can be fairly substantial. But I still think you should get a quote so that you have an idea as you're figuring out what avenue you want to take to pay for that care, okay? So what is the last way, the most common way that people pay for long-term care? So again, that's broad. That's nursing home care, and that's also in-home care, is to rely on government benefits, all right? Either Medicaid or Veterans Aid and Attendance. In today's presentation, I'm going to talk about 30 seconds about Veterans Aid and Attendance, and that is only because the qualifications for Medicaid and Veterans Aid and Attendance are very different. So it is essentially impossible to qualify for both. You're either going to get Medicaid benefits or you're going to get Veterans benefits. A lot more of you are going to be looking at Medicaid, and even for those of you who are veterans, a lot of times when they look at those two options, a lot of veterans go ahead and go with Medicaid benefits because they can be a little bit easier to qualify for and sometimes have better benefits depending on your situation. So if you are a veteran, you want to talk to somebody that's knowledgeable in both areas, but for today we're going to focus on Medicaid. And this is Indiana Medicaid that I'm using for an example here. Every state has its own rules. So the numbers you see, the options you see might be different if you've come over from Ohio or down from Michigan, okay? But in general, just to let you know, if you do no planning whatsoever, okay, and you are single and you apply for Medicaid, you are not going to qualify for Medicaid benefits until you have only $2,000 left to your name. Now, that does exclude income-producing assets, all right? So that doesn't include your farmland that you're getting cash rent on, okay? That doesn't include maybe an interest in an LLC with a family that's an operating entity, okay? Because the state of Indiana has figured out they want that income. So they're not going to make you sell that farm immediately. Okay, they're not going to make you sell that LLC interest immediately. They want the income off it. But everything else, anything that's not income producing, you're going to have to use. If you do eventually get down to $2,000 and qualify for Medicaid, all of your income is still going to go to the nursing home to pay for your care. And then Medicaid is going to make up the difference. So let's say you have $3,000 in monthly income, and your monthly bill is $7,000. So that $4,000 that you're short, that's what Medicaid pays, okay? The problem comes when you pass away. Because once you pass away, Medicaid then makes a claim against your estate for any amounts that it paid out on your behalf. So if you were in the nursing home for an extended period of time and Medicaid paid out $150,000 on your behalf, now they're making a claim against your estate, and how much money do you have in your bank account? Less than $2,000. That's when the farm gets sold to pay for that claim, okay? So that's for a single person. It is very different for a married couple because there are lots of laws in place to protect what we call a community spouse. So let's say husband is going to be going to the nursing home and wife is going to be staying at home. She's healthy. She's doing fine. She's called the community spouse for Medicaid purposes. And your home, one vehicle, and any income-producing real estate and business assets, so all that farm ground or that interest in an operating entity, can be transferred to the spouse and as exempt and not taken into consideration in the application. With the rest of your assets, so think about investment accounts, bank accounts, the community spouse can get up to half. So let's say after we've transferred the real estate and the business interest to the spouse and the house, they've got $200,000 left in liquid assets. The wife would get to keep $100,000. There's a maximum and a minimum amount, but it's usually half. The other $100,000 is attributed to the husband, and that has to be spent down to $2,000 before he can qualify. Okay, so that's actually fairly good news for some of my married couples in that if you've done no planning, your spouse is going to be fine, okay? Your spouse is not suddenly going to be poor because one of you goes to the nursing home. The problem is that once one of you pass away, or if both of you are in the nursing home, if there's no community spouse, now there is no person that you can transfer assets to without causing an issue with Medicaid eligibility. So moral of the story, if you've got a spouse at home, there's a whole lot that can be done to protect assets. But if you are single or your spouse passes away and you become single, okay, we're in trouble and that farm is at risk. So what do? You need to get those, it says resources up here because that's what Medicaid calls it, but assets. You need to get those assets that are most important to you out of your name and your spouse's name at least 5 years before you apply for Medicaid. Now, if I knew when that was, I would not have this job. I would be on a beach in Jamaica if I could predict when you're going to the nursing home, but I can't. So I would say for a lot of my clients, the ideal time to start thinking about gifting assets away is typically in kind of early to mid 70s or shortly after you get out of the farming business, but you're a farmer, so you never do that. So let's go back to the mid 70s, okay? The three most popular ways to do that is, again, outright gifts, like Dan talked about earlier, a gift of real estate with a retained life estate, which does not work in most states other than Indiana. So if you're not from Indiana, that's probably not for you, or gifting to an irrevocable trust. And I would love to go through all three of these options and the pros and cons of each, but we don't have time today. But hopefully from these slides, you kind of figure out which category am I in. Am I in the cash flow category? Am I in the, okay, I need some assistance? Am I in a long-term care insurance plus my income category? Or am I relying on Medicaid? And if I'm gonna rely on Medicaid, you need to see someone in advance to make sure we can protect some of those assets. And then I'm going to spend almost no time on this topic because it's very easy. How's that? Not taking liability creditors seriously. So what are your biggest liability creditors? Your farm equipment, farm machinery on the road, employees or family members using that farm machinery equipment. We're talking grain bin accidents, auger accidents, overspray, groundwater contamination. You guys can read. Injury, personal injury or property damage by livestock, slips and falls. You guys can think of more, okay? My big thing I have to say about it is a lot of times people will come into my office and say, okay, I want to set up an LLC, a limited liability company for liability purposes. And I say, great, let's have that talk. But I think there are a lot of attorneys out there and others that will try to say that a corporation or an LLC is the end all and be all of liability protection. And Dan, I believe, would agree with me, and Tony, that your first level of protection is always having adequate insurance. Okay? Because basically, when you're purchasing insurance, you're purchasing an attorney that's going to defend you if you get sued. In fact, that's what my husband does for a living. He is a trial attorney for an insurance company for the entire northern portion of Indiana. So if you happen to have that particular insurance company and you get in a car accident and someone sues you, my husband will be your attorney whether you like it or not. But he's big and intimidating, so it's good.
Very scary,
right?
Very scary.
Very scary man. No, that's what you're buying, right? So that is your first line of defense, and having an umbrella policy, okay, in case you would get sued and your policy limits, what you have to pay is above your policy limits. Your second line of protection then is business entities. Basically, you've got three different groups of assets that you need to think about. You have your highest liability assets, which is going to be your farm machinery and your farm equipment and your livestock. Okay? You want to separate those high liability assets from your highest value assets, which for most of you is going to be your farm real estate, because it's worth $18,000 an acre right now. And then ideally, you also separate your personal assets from your business assets, so your home or your other personal belongings. There are so many types of business plans that can be put in place that involve partnerships and corporations and limited liability companies. But I would say this is one of the most common, would be to have one operating entity, either a corporation or an LLC, and that's going to hold all your farm machinery, your farm equipment, your stored grain, et cetera. Having a separate land holding LLC, and leaving only your personal assets in your personal name. So what that does is, if that grain truck that's owned by the operating entity gets in an accident, are you going to get sued? Yes, but you have insurance, okay? And even if you have to pay out, only the other assets in this operating entity are at risk, okay? The land is in a different entity. Your home is in a different entity. Or not a different entity, it's in your name. Your investment accounts are in your own name. So you're basically, it doesn't mean you're never going to get sued. You are, okay? But you are separating what's at exposure. And that is it, because I'm sure I'm over my time.
Well, and but just to kind of wrap up with a little bow here, because we've had so many conversations about this kind of stuff. And again, I go back to what you said before in one of our conversations when we were creating radio commercials is that if you've been on one farm, you've been on one farm. And so if people are sitting here thinking, I'm going to walk away from this with the answer, there's no the answer.
No, you're right. There isn't an exact plan for everybody. And one of the questions I get a lot is, okay, do I use a corporation? Do I use a limited liability company? Do I use a partnership? A lot of the answer to that question isn't even legal. That's a tax issue. So your accountant and your financial advisor should be in on this conversation.
Boy, what a great,
with your attorney.
What a great transition.
There's your bow.
Into Tony.
Some of you in here know me. I've been with Dan about 20 years, Tony Crowell. My practice in Gordan and Associates, I'm kind of the odd man out, the odd duck, because all of those other people are estate planners and things like that. I'm a transactional attorney. I deal with real estate. I set up these entities like what Michelle was talking about. I sat down with clients and we decide which entities are best for them to use for their operations. And as she said, having the accountant involved in those discussions is very important. So because I'm the odd man out, the odd duck or whatever, I get to talk about government regulations, and nobody else wanted that. So not saying I wanted it, but I got stuck with it.
I think that's called the short straw.
That's exactly right. So I'm not going to get into this very deep. If you think of yourself when you're a kid, you're sitting on the side of the lake, you pick up a rock and you skip it across the lake. That's how I'm going to hit these subjects, okay? I'm just going to touch them because they're so deep, especially this first one, and it's pretty current. So, waters of the United States, WOTUS. So that's the first topic I'm going to talk about. If I have time, we'll go into DNR and drainage regulations. And just so you know, I've talked at the Farm Bureau drainage seminar every year for 3 or 4 years in a row. Area Plan Commission rules and regulations, County Drainage Board and the Surveyor's Office, and then utilities, how those impact your farm. And again, these topics aren't necessarily going to cause you to lose your farm, but they can affect how you use your farm and the profitability or the value of your farm. So you're not going to lose your farm in this area, but they do control how you can use it. So waters of the United States. So back in December of 21, the EPA and the Army Corps of Engineers published a proposed rule to offer up a clear and concise and easy to understand definition of waters of the United States. Everybody agree with that? Okay, yeah. So anytime the government gets involved, they clarify everything.
Yeah, I'm from the government. I'm here to help or mess it up.
Right, right. So I'm going to read this because I couldn't memorize it. You know, this is the proposed rule also became final it will become final 60 days after it's published in the Federal Register, and I'm not sure if it's even been published yet, but I don't know that there are very many, if any, changes in the final rule from what the proposed rule was. So the way this happens is an agency publishes a proposed rule in the Federal Register, and they invite input from the public. And so since December 17th of 21, the EPA and the Army Corps of Engineers have conducted public sessions to receive public input, and then they finalize that rule. They may take some of those suggestions and incorporate them into the proposed rule, and then they publish a final rule. So this is the definition of waters of the United States as published in the proposed rule, and which I'm assuming is going to be the final rule. Traditional navigable waters, interstate waters, and the territorial seas and their adjacent wetlands, most impoundments of waters of the United States, you never use the word you're trying to define in the definition of the word. It just doesn't make sense. Tributaries to traditional navigable waters, interstate waters, the territorial seas, and impoundments that meet either the relatively permanent standard or the significant nexus standard. Wetlands adjacent to impoundments and tributaries that meet either the relatively permanent standard or the significant nexus standard, and other waters that meet either the relatively permanent standard or the significant nexus standard. Clear? So you can walk out on your farm and see some water, and you know whether or not it's a WOTUS, right? Okay. Yeah.
The significant nexus, that's the part that trips everybody up. And to see it in this new rule, Tony, is again just very disheartening. Thought we got rid of that, thought we simplified that, but you've gone deeper into it than I have. Originally, and this seems like we've gone back to the Obama version, it was about 3/4 of a mile, give or take, either side of anything wet was what they were going to control. Is that where we are again? Significantly nexus?
Well, I don't think there's any distance that you can pick that's going to tell you whether or not you're within jurisdiction. So what happened was Trump came into office and he changed the rule. He changed the definition. And now that he's out, Biden's administration, they're coming in and they're going back. You're correct. They're going back to what it was before and trying to clarify it even more. So the reason why you need to know if your property has WOTUS or not is because that determines whether or not EPA or the Army Corps of Engineers has jurisdiction over that body of water. And so that's kind of the first determination. And then if they have jurisdiction, then if you're going to do something with that water, you got to get a permit for it. All right? So navigable waters and adjacent wetlands to navigable waters are clearly within the WOTUS definition. Can you drive a boat down it? Is there a wetland adjacent to it? We'll talk about adjacent in a minute if I have time. That's kind of the first thing. And the whole purpose of the Clean Water Act was to try to clean up the waters of the United States. They'd gotten pretty polluted and everything. So, you know, it's an honorable thing to try to do, but when you're imposing and impairing other people's rights on their land and stuff, it gets a little difficult to balance those interests out. So non-navigable waters, that's when these two tests come into play. If it's not a navigable water, you either got to look at the relatively permanent standard or the significant nexus standard. Now, some of this stuff is kind of legal jargon, and us attorneys love it because it creates litigation, and that's how we make a living. Not us, we're not litigators, but you know, so you see who's making these rules, and you kind of trying to figure out, are they just trying to, you know, create opportunities? Anyway, the relatively permanent standard, waters that are relatively permanent, there we are again, using the words in the definition, standing or continuously flowing, and waters with continuous surface connection to those waters. That's the relatively permanent standard. But as you said, the significant nexus standard is the one that is so vague and ambiguous and open to interpretation. There is no way you can try to take that test and determine if you have WOTUS on your property or not. You're going to have to hire an attorney, you're going to have to hire a consultant, and they're going to have to tell you whether or not it's WOTUS, and that's expensive.
But Tony, isn't one of the other issues as well, particularly as it applies to our farmers, that once a water is designated, then they have control over the land that's adjacent to it, and that's where it becomes an issue for farmers.
They will, to the extent that anything from that land is going to get into that water. Then, they're going to control that. They're going to have a jurisdiction over it, and they may monitor it or whatever. There could be civil penalties. There could be criminal penalties, criminal fines, or criminal action. So it all depends upon what is going on. So here's the significant nexus standard. Waters that are either alone, and this is as defined in the proposed rule, which should be the final rule, waters that are either alone or in combination with similarly situated waters in the region significantly affect the chemical, physical, or biological integrity of traditional navigable waters, interstate waters, or the territorial seas. So basically what they're looking for there, I believe, is there something that is coming from your land, getting into some kind of a water stream or tributary or whatever, and it's carrying chemicals, and it gets into a navigable water, and then we've got pollution or something like that. That's kind of what they're looking for. Can it get from A to B, from your land to here, and how does it get there? And that they're going to use that to determine whether or not they have jurisdiction. So what's a wetland? Does anybody here know what a wetland is? Kind of got a good idea? It's like wet, but it's not a body of water. It's not, surface water. We all kind of have, cattails, things like that. So how do we know if the wetland is WOTUS or not? So if the wetland is adjacent to an upstream tributary, not a navigable water, then we got to use this significant nexus test to determine whether or not the Army Corps of Engineers and EPA has jurisdiction over that wetland. So there's a case right now, Sackett versus EPA. It was argued before the U.S. Supreme Court on October the 3rd. So in preparation for this talk, I thought, well, I'll look at the case. Well, instead of reading the briefs or reading the lower level cases, through the Court of Appeals to get up there, I read the oral arguments from the attorneys arguing the cases both for the government and for Sackett. A very interesting reading if you got about 2 or 3 hours. What's really interesting, if you've never had an opportunity to observe or read about how the Supreme Court works, the attorneys come up to the podium and they start making their argument, and they get about 5 minutes, if they're lucky, into their argument, and then they start getting hammered with questions by the justices. So the questions that are asked kind of give you hope, a little insight of either where they're going or what the justices are concerned about. And they spent 75% of their time on what does adjacent mean. What does adjacent mean when you're talking about a wetland? And in this case, they were dealing with a wetland that had been filled in by the property owner, and it was a residential development. They had filled in the wetland with stone so that they could build their house, and they got in trouble. Determining whether or not the wetland is adjacent, whether you use the significant nexus test, the attorney for Sackett was proposing what they believe to be a more simple, straightforward approach in making that analysis. I have no idea where they're going to come down on this. Well,
and Tony, one of the issues and one of the reasons why we bring this Sackett case up is because the Sackett case originally was an effort to try and clarify and simplify the definition that Tony's kind of poking fun at here in terms of definitions, but to try and simplify that and get a solid ruling out of the Supreme Court so that we can move on with it. And one of the big problems here recently, Tony, that maybe you can comment on is that gosh, everybody from soup to nuts, A to Z, the corn growers, the Farm Bureau, and everybody in between asked the EPA to hold off on putting this new rule out until we got a ruling in the Sackett case, which would give us some guidance as to what that definition is. So, Tony, as I understand it, about the time the Supreme Court is coming out is about the time the 60 days is up. And so answer me this. If the ruling comes out before the Sackett case ruling comes down, what implications does that have for farmers?
If the 60 days expires before the opinion comes out on Sackett, is that your question? Well, obviously, if the 60 days expires, the final rule is final, and that's the rule until the Supreme Court's decision comes down. And if the Supreme Court decision is published after the 60 days, then we will have to look at that decision and how it impacts the new rule to determine whether or not whether they work together or against each other. And there may be parts of the new rule that will be declared either unconstitutional or against the Commerce Clause, or vague and ambiguous. Who knows?
Trying to whittle this down even further to a real fine point. When that ruling comes out, and then Sackett follows that, that rule stands until litigation clarifies it. Correct?
That's true, because
unless
the Supreme Court takes the opportunity and they review the rule and they make some comment on the new rule in their opinion.
So the reason I ask that is because some of the problem with some of this, particularly for landowners, farmers, people who own land and want to build a home on it, and like you said, fill in with some gravel so they can build a home, et cetera, et cetera. The EPA and the Army Corps of Engineers, unfortunately, under particular administrations, have decided that what they're going to do is they'll just come out and slap fines on you until we get this resolved. And if you don't comply, then it's going to be X amount every single day. Is that what this would set us up for?
Yeah, I can't speak for the EPA or the Army Corps and Engineers on how they're going to enforce it, but you certainly would be putting yourself at risk if you're violating the rule. And that kind of gets us into a real kick. I don't know where we are on time, but the Louisville office of the Army Corps of Engineers has jurisdiction over this area. And I've got a map of the state of Indiana up here that only a small portion of the upper counties and the western counties, one's in, so Chicago has that jurisdiction, and Detroit has another jurisdiction. But most of the state is covered by the Louisville office. So if you want to know, now here's what the agencies, wave their flag and say, hey, but it's free. It's free. If you want to know if they have jurisdiction over your property, there's a form you fill out and you submit it to the office in Louisville, and they will tell you whether or not they have any jurisdiction over your property. And that jurisdictional ruling is good for 5 years, okay? So, and that's a free application. But if they come back and say, yeah, we got jurisdiction, now what do you do? Well, now when you can appeal that decision, but now you got to hire the attorney, you got to hire the consultant, and it costs big dollars to fight that determination.
Okay, and then real quick, because we are winding down on time here, but here in our area, one of the big concerns is that we're in some significant watersheds that go into Lake Erie. And so that's a concern. I haven't talked to any farmers who say, I don't care. They all care, and we're all trying to do something about it. But reflect on that just a little bit for us.
Yeah, I mean, I don't think that anybody believes that someone's going to go out and intentionally misuse their property with the intention of jeopardizing the waters of the United States. All of you in here are farmers, and you will use your land the best way you can, and you will use best farming practices to do that and manage any potential transmission of what you do chemical-wise or whatever on your property, past your property lines. You will do that. The government's just stepping in, and they want to police that. They don't. I don't believe that they necessarily trust that everybody's got the best interest in their heart for, waters of the United States and the Clean Water Act. So that's a difficult thing. So here are some links, different web things that you can get on DNR's website for drainage regulations. It would be in your packet, all the little things there. So you can go to that link right there, type it into your search browser, and you can click on any of those links to look at Indiana floodplain mapping and so forth. This link will show you the roster of navigable waters by county in the state of Indiana. So that could be helpful. Let's see. So I don't know. I don't really have time to get into Area Plan Commission and things like that. But if anybody has any questions, Dan's up here. Michelle can come back.
Well, and you guys are going to be in your booth, which is down in the lower area for a while to take all kinds of. Oh, you're going to stick around in here for a bit? Okay, great. So if you'd like to talk to any of the attorneys, I would say, Tony, we probably need to get on the radio and talk about this, but only because I think we learned some lessons with solar, or with wind rather, and now solar is coming in with a little bit more of a vengeance than it had before. And some of those contracts, you better be sitting down with somebody like Tony before you sign on to one of those contracts, because a lot of people really got shafted by some of that sort of stuff.
And I've reviewed over 50 solar leases, easements, which, depending on the.
Find any really good ones? No.
I have. I have found that they are willing to work on the language of the agreements, within reason, because it's in some cases a 40, 50-year relationship. It's a marriage, and they don't want to go into that relationship pissing somebody off or trying to take advantage of you. But you got to be careful. You got to have somebody looking out for your interest, because they don't know. When they first started this, they didn't know what farming was. Right. They didn't know how what they want to do would affect farming, drainage and things like that. So they had to be educated a little bit.
Well, and I don't think that we knew that some of those big blades on some of those windmills don't last forever. And that got to cost a lot of money to take them down. They don't decompose. We haven't figured out yet how to recycle them. There's a lot of stuff with those windmills that unanswered questions. And I think, Tony, just real easy answer to this one. Seems like the solar and the wind are forerunners, perhaps, maybe in structure of the contract for some of these carbon things that they're coming out with. Or at least are we going to learn something from the previous step before we get into the carbon?
That's interesting you bring that up, because I was involved in negotiating a carbon sequestration lease for a client of mine, fairly within the state of Indiana, where the company leased the infrastructure or the strata underneath the surface so that they could store carbon underground. And it was a very interesting process, because it's cutting edge right now in the state of Indiana. So yeah, that's coming, and the pipelines to pipe the stuff and those sorts of things. So it's coming. It's all this green energy stuff is getting pushed.
Yeah, more complicated stuff that you probably need to talk to Gordan Associates about. So hey, thanks a bunch for everybody from Gordan Associates. Appreciate that. And like I say, Michelle's in the back. Tony, Dan, all going to stick around for a while. So if you want a one-on-one conversation, you got it.